I want to talk about someone who has gone through many lawyers who simply cannot keep working with them and have gotten to the point that they are currently representing themselves pro se and writing letters to the court. No, not Sarah Boone. I'm talking about Rudy Giuliani. Now, Rudy Giuliani lost a defamation case, and there were issues during the case where reportedly he wasn't working with his lawyers to actually do discovery as he had to do. Now, after he lost the case, there were brand new issues where Rudy was saying he lived in one location, but he spent all his time in a completely different state, or he said he couldn't find an item, or an item he was ordered to turn over, he now claimed he actually had gifted it away. Quite a few issues. One of the examples would be he couldn't find a vehicle he had to turn over, from my understanding, and then he was spotted driving it to go vote, and then he turned it over without the title, but thought that was good enough because the court just said turn over the vehicle. And as you can imagine, lawyers do not want to work with him. But Rudy has a different understanding of what happened that he's decided to put forward here. And we're going to talk about that and how he had a very blue Christmas where he got some court filings sent to him on Christmas Eve. Dear Judge Howell, I am the pro se defendant in the above referenced action. I write to request a 30-day extension to file a response in opposition to plaintiff's motion for civil contempt, filed November 20th, 2024. If this request is granted, the response in opposition will be filed January 2nd, 2025, instead of December 2nd, 2024. The deadline that was set by the court. See November 21st, 2024 scheduling order. The primary reason for this requested extension is that I need more time to find an attorney to represent me in this matter, especially now that plaintiffs are making allegations seeking civil contempt. I have spoken to 4 attorneys, and each attorney has declined to handle this matter because they believe Your Honor is unreasonably biased about Trump-related matters and ideological rather than logical. One said it was a foregone conclusion and a no-win proposition. Among other numerous reasons, your handling of the J6 cases is considered by many to be most unnecessarily harsh. They also cited objections of their firm to the effect on their practice. Some were willing to assist in my other cases, but not this one. Additionally, the difficulty of finding an attorney has been exacerbated by the Thanksgiving holiday. There is no prejudice to plaintiffs in granting this extension, since I will agree to abide by their interpretation of the restrictions on what I consider my right of free speech and to defend myself against their false statements until the matter is heard. To the extent that the court is not willing to give me an extension to find an attorney, I ask for at least 3 weeks so that I can prepare my response on a pro se basis to properly set out before the court that the purported comments mentioned in the plaintiff's motion for contempt were to defend myself against their comments and only relate to the judicial proceedings and not on the comments about the plaintiffs. This is the first request for the extension to oppose the motion C by the court. Respectfully submitted, Rudolph W. Giuliani, defendant pro se. So Rudy, if you didn't know, was continuing to defame these people after losing a defamation lawsuit in addition to not turning things over as ordered. And when he couldn't find a lawyer to stick with him because they kept quitting, reportedly blaming Rudy, not Trump, not whatever, Rudy, he blames the judge. Now we continue on because before I continue on, I do want to mention that Rudy, you'll notice here, mentions January 2nd. He actually tried to change these dates because the way things ended up, essentially, Rudy found out that he might be in court and might miss things in January, such as Trump's inauguration. And he sent another letter, which I don't have on me at the moment, saying he had a right. I believe it was a letter. It might have been said in court itself, but he had a right to attend that inauguration, and the judge told him, no, he has to be in court. So, with that being said, let's talk about some things that were filed recently. So, plaintiffs Ruby Freeman and how can I not say this? Moss respectfully submit this letter in response to the court's December 20th order, directing the parties, including the intervenor, Mr. Andrew Giuliani, to submit letters by December 23rd at 5 p.m. A lot of stuff got submitted. I'm not going through all of it. This is very light to give you an idea this is going on. And see what people are interested in. Listing their proposed witnesses, topics of their testimony, requests for amount of time for the direct examination. So, witness Rudolph W. Giuliani will call. Plaintiffs expect Mr. Giuliani to testify to the ownership status and the physical possession of the World Series rings, as well as to the circumstances around which he purportedly gifted the World Series rings to his son. So he's supposed to turn these over, and he's claiming he can't because he already gave them away to his son. As you can imagine, they still want them. Here we have another Rudy Giuliani. Plaintiffs expect Mr. Giuliani to testify about his actions and intentions relating to establishing a homestead at the Palm Beach condo within the means of the Florida Constitution. So if I'm remembering this right, because I've kind of lightly followed this case, Rudy Giuliani has lived in New York. A lot of his items are in New York. He does a show in New York. So he's there in New York, because he's live streaming from New York. But he's claiming that a much better property in Florida is actually his homestead, and therefore he'll get to keep it. But they're arguing he doesn't live there, so it doesn't apply, at least from my understanding. Well, here we have another Rudy Giuliani letter, and as you can see, this is on Christmas Eve. I, Rudolph W. Giuliani, declare and state under penalties of perjury that I am the defendant in this action. I respectfully submit this declaration in opposition to the plaintiff's motion to hold defendant in civil contempt and impose sanctions. I respectfully submit that this court should deny plaintiff's motion for an order holding me in civil contempt and imposing sanctions. October 2nd, 2024 stated, the court finds that all of the item interests in PP 16 through 18 should be subject to turnover and receivership. October 22nd, 2024, directed the turnover of the following. The shares evidencing defendant's interest in that location, which signed blah, blah, blah. All rights and interests in cause of action, fees owed to Mr. Giuliani for services rendered 2020 and 2021 to former President Trump's presidential campaign and the Republican National Committee. Plaintiffs have not requested anything regarding this. So basically, Donald Trump didn't actually, from my understanding, pay Rudy Giuliani. So it was listed as an asset he had. So they can go after Trump to force Trump to pay Rudy, and then they take it, essentially, from my understanding. Again, I've from the outside looking in, I'm not super dug into this case, but I have kept up a little bit. The non-exempt cash in the checking accounts held at Citibank with accounting numbers, okay. I turned over all non-exempt cash. They said they did that. Mercedes-Benz model SL500 model year 1980, I turned over the physical Mercedes-Benz and complied with this requirement, and plaintiffs acknowledged that they received the Mercedes-Benz. I had the vehicle delivered to Miami, Florida, as requested by plaintiffs. From my understanding, he did not actually include the title. That's why he's saying the physical, but not the title. Various items of furniture, television, sports memorabilia, signed Reggie Jackson picture, signed Yankee Stadium picture, signed Joe DiMaggio shirt. Exhibit 1 to Plaintiff Counsel's declaration shows that I turned over 42 items, which is more than what the court order specifically requires. I delivered and turned over various items of furniture. Book cabinet, 3 living room end tables, living room leather sofa bed, storage bed drawer, leather office chair, living room office table, folding upholstered chairs, 2 red leather overstuffed chairs, drop leaf table, rolled mattress, seat cushions, cushioned ottoman, lamp shades, lamp and pillows, master bedroom slats and hardware, master bed side rail, sofa bed legs, nightstand, master bed footboard, master bed mirror, and storage bed side rails, master bed headboard, master bed dresser. Plus, there was a significant amount of furniture contained in the New York cooperative apartment, which was also turned over to the plaintiffs. The court should note that I turned over what was required to turn over, and more. Television. I turned over a television carrier pack wrap. Sports memorabilia. I turned over sports memorabilia, including Yankee picture, Yankee banner, Mickey Mantle picture, John Daly framed art, Derek Jeter picture. The following photos are contained in plaintiff's exhibit, which shows the sports memorabilia items turned over. There is no Reggie Jackson picture. The picture was Derek Jeter. The Yankee Stadium picture is the hallway Yankee picture. There is no signed Joe DiMaggio shirt I possess. I believe that the signed Joe DiMaggio shirt was hanging in the New York cooperative apartment at the time the apartment was turned over to plaintiffs. The court order did not specifically state that I had to turn over the Yankee banner, the Mickey Mantle picture, the John Daly art, or the Derek Jeter picture, but I turned over these items to comply with the court's order. I have given all the items that the court required me to provide that I possessed, and out of abundance of caution, additional items were provided to the plaintiffs. Costume jewelry and diamond ring. I do not possess any costume jewelry. I turned over my diamond ring. I turned over 18 watches. I turned over all the watches that I possessed and retained one watch that is exempt from judgment under New York, Florida law. I don't know if when he says he possesses, I don't know if any of these were supposedly gifted or sold before. I don't know. I respectfully submit that the items which I returned to turn over, which I was required to turn over, I turned over. The court should see that I gave everything that I could. I gave items of furniture and sports memorabilia that were not specifically listed on the court's turnover order, but I gave them anyway to ensure that I was complying with this court's order. The instructions require that I was required to amend my responses on the information subpoena, which I did. The instructions order required that I tell the plaintiffs where the outstanding property listed on PP 1718 of the turnover order was, which had to be delivered to plaintiffs. It is an undisputed that I told the plaintiffs where the items were. They were in a storage facility in Roma, New York, where plaintiff's attorney went and saw all of the items located there, and thereafter I had the items removed from the storage facility in New York and delivered to the storage facility in Queens as directed by plaintiff's counsel. As required by the court's November 2022 order, I had all of the property at the CTS facility in Rocanoma, or whatever that is, New York, segregated, separating the property that was subject to the court's turnover order from items that were not subject to the turnover order. I complied with this requirement. I also provided a detailed list containing pictures of the segregated receivership property. Let's see here. I provided the location of the New York-based storage facility for plaintiffs. I complied with the court's 3 orders, turnover order instructions. I have not intentionally or willfully disobeyed any of the court's orders or plaintiff's discovery demands. If any documents were not produced by me, it was because I did not possess them or was unable to locate them. The following documents were served upon the plaintiffs by my counsel for compliance with discovery. So this would be a bunch of different things he had given to the plaintiffs. I respectfully refer to and adopt the plaintiff's memorandum of law. I respectfully submit that I fully or substantially comply with the court's turnover order, instructions order. I respectfully submit that I should not be held in contempt or sanctioned. Wherefore, respectfully request that the plaintiff's motion for contempt and sanctions be denied in its entirety, and for such other further relief as this court deems just and proper. And there we have a Rudy Giuliani signature. But there is more. So this was after. As you can see, this is today. The plaintiffs, Ruby Freeman and Moss, respectfully submit this letter in opposition to defendant Rudolph W. Giuliani's letter motion for a protective order. The letter motion seeks a protective order providing that defendant need not respond to plaintiff's interrogatories number 4 or 8 and the 2 interrogatories the defendant has thus far refused to answer in full, including after the court granted plaintiff's motion to compel and order defendant to answer by December 20th or show cause why he should not be held in contempt. Defendant's letter motion should be denied. Defendant's responses to interrogatories 4 and 8 were due November 20th, 2024. The letter motion asserts objections that could have and should have been raised by that date, and are consequently waived. For the most part, defendant's objections have also been rejected by this court on the merits as well. The letter motion is thus, in effect, a motion for reconsideration of the court's order granting plaintiff's motion to compel, but it is well settled that a motion for reconsideration is not a vehicle for relitigating old issues, presenting the case under new theories, securing a rehearing on the merits, or otherwise taking a second bite at the apple. And here we just have an explanation of the things he's not answering. It involves like financial, legal, professional stuff he did. That is number 4. And I can't remember what number 8 was, but number 4 was involving that, and they're basically saying if he had a problem with it, he could have argued that, and they could have changed it, but he just didn't answer. And while it is true that the court contemplated that defendant could have sought a protective order to remedy his confidentiality concerns, ECF number 139 at 8, the protective order defendant now seeks would not require confidential treatment of his answers, but relieve him of the obligation to answer altogether. A result already foreclosed by the court's decision granting the motion to compel. Defendant still has not sought a protective order that would permit him to answer the contested interrogatory subject to restrictions on their disclosure or the use of outside his litigation. Evidently, he is not actually interested in that form of relief. Further, because the defendant has not shown cause why he should not be held in contempt for his refusal to provide complete answers to the subject interrogatories, the court should hold defendant in contempt and at the January 3rd, 2024 hearing consider and enter the following adverse inferences. It should be 2025. that the identities and correspondingly locations of the defendant's professional services providers would show that Mr. Giuliani did not treat the Palm Beach County condo as his permanent residence as a matter of subjective intent and actual occupancy, that the identities and correspondingly locations of the defendant's professional services providers would show that Mr. Giuliani treated the Palm Beach condo as a vacation home. That defendant's true answer to interrogatory 8 would show that defendant's discovery responses and disclosures were incomplete. Oh, I think number 8's involving his lawyers reportedly claiming that he refused to help with discovery, and they wanted to have the lawyers or something like that get involved and explain. The defendant's true answer to interrogatory number 8 would show that Mr. Giuliani's unproduced and undisclosed discovery would have been relevant to the questions of Mr. Giuliani's homestead. So basically, they're wanting to hold him in contempt because of that condo, right? Like, Rudy Giuliani is focusing on other stuff. He doesn't want to talk about this one. They're claiming he lives in New York, he live streams in New York for his whatever show, I don't know how often it is. He has a vacation home in Florida, and he's trying to keep it. And they wanted to have the evidence, showing when he travels there, the money going in, out, things like that, things that could prove whether it was a vacation home or not, and Rudy didn't want to turn it over. And if I were to guess, he doesn't want to turn it over because it would show that it's his vacation home. And if it's a vacation home, he has to turn it over. And if you're not familiar with this case, you might be like, they're really getting things like his beds? And the answer is yes. Rudy Giuliani lost essentially everything he legally can lose because his defamation case went that poorly. That is why he's fighting, and he's doing things that no lawyer wants to put their name to. So this is all coming to a head in January. So I don't know if people want me to cover it and do more digging and do like better videos covering it, but there's a lot here, and it's of course going to end up being he's whatever happens when I suspect he's going to lose. He's going to blame it because they hate Trump, right? But Rudy, it's pretty damning. I've looked into it at various points and done dives, but I don't think I've ever done like a full following of it live, just whenever something interesting happens. And I saw there were a bunch of filings on Christmas Eve and the day before Christmas Eve, and I've had this tab open, and then I saw that they, some of the stuff filled in, so I thought I'd just let you know he did not have a very Merry Christmas.